Convener, thank you.
Yes, Dean Lockhart, please.
Thanks very much, Convener, and good afternoon, Mr Gove. My first question relates to the policy objectives behind the legislation. This committee has heard evidence from a number of stakeholders that maintaining free trade across the UK is essential to protect jobs and livelihoods in Scotland. In fact, Mr Gove, you mentioned that some 550,000 Scottish jobs rely on that free trade. On the other hand, the Scottish Government has said that this legislation is not required and is instead pursuing a policy of keeping pace with new EU legislation, which will likely create new trade barriers between Scotland and the rest of the UK. So I wonder if Mr Gove could share his views on the adverse impact of these new regulatory barriers, and can he also confirm the analysis that it would be Scotland that would suffer the most economic damage if we lose free trade access to the rest of the UK internal market?
You're absolutely right, Mr Lockhart. The first thing to say is that the principle, as I understand it, of the continuity bill that the Scottish Government has been putting forward is entirely that it should keep pace with EU legislation. Let's imagine that the EU were to legislate in certain areas and the UK were not, or indeed that the UK were to legislate, which is entirely possible, for higher standards, but the Scottish Government were not to do that because it thought it was more important to keep pace with the EU. The consequence of that would be divergence, and divergence that would create strains on the internal market, that would work against the interests of Scotland's businesses and consumers. And it is the case, as you quite rightly point out, given the scale of trade in Scotland with the rest of the UK internal market and the dependence of so many businesses and so many jobs on that trade, that it would have an adverse effect. And so the bill is there to protect Scotland's jobs, protect the access of Scottish consumers to goods from elsewhere in the UK, to do that in the context of a devolved settlement. And also, it should be said that whatever admirable ideas might emerge in the EU, I'm sure it will be the case if they're very good, that they'll be adopted in the UK. Were they to be adopted by the Scottish Government simply for the sake of keeping pace with the EU, then it would be the case that that Scotland would not secure any additional market access as a result to the EU, but it might impede market access to the rest of the UK.
Okay, thank you for that answer. So, in essence, you would be concerned that the EU continuity bill could create these significant new barriers to trade and ultimately cost jobs in Scotland?
Yes.
Thank you very much for that answer. Can I move on? My next question relates to the hypothetical concerns that the UK Government may lower regulatory standards in the context of future free trade agreements. However, when we look at the evidence, the revealed preference that you mentioned earlier, in many areas, the UK already has higher domestic standards than the EU. For example, in areas of health and safety, maternity leave, paternity leave, to name but a few. And in the first major free trade agreement signed by the UK Government following Brexit, the Economic Partnership Agreement with Japan, this didn't result in any lowering of regulatory standards. So I wonder, Mr Gove, would you be able to expand on the UK Government's strategic priorities when negotiating future free trade agreements and indicate whether maintaining world-leading regulatory standards will be central to the UK Government's approach to these free trade agreements?
Yes, I think it's you're absolutely right to say that we see our role in shaping the international trade agenda, not just in promoting free trade, but also in promoting higher standards. And whether that's looking at supply chains overall in order to make sure that we're promoting the highest environmental or animal welfare standards, or whether it's encouraging other nations to adopt the high standards that we have when it comes to employment and social rights, we absolutely do believe in maintaining and enhancing those standards. We won't sign free trade agreements that compromise those standards. And you're quite right in saying that while the EU has provided a floor for certain standards over the course of the last few years, that the UK government, under Conservative, Coalition and Labour Prime Ministers, has always aimed higher than the EU has.
That's extremely helpful. Thank you very much, Mr Gove. That's all I had, Convener.
Thank you, Dean. Patrick Harvey, please.
Thank you, Convener. I also wanted to ask Mr Gove about some of the evidence from Professor Duggan last week. in the hope that this time we might get an answer that amounts to saying more than just, oh no, it isn't. Professor Dugan said that within the EU, when issues around regulatory divergence crop up, effectively it says it flags up to the European Commission that there is a trade barrier, a legitimate trade barrier, and that maybe the Commission should think about harmonisation. In that way, the emergence of legitimate trade barriers acts as a kickstart to the process of political dialogue, whereby the Member States and the EU institutions begin to think about how serious a problem it is and what the best solution is. He says the problem with this bill is that mutual recognition is not being used as a way of identifying problems so as to help find a political solution. In effect, the bill is saying we've identified a problem and we're going to solve it by sweeping away devolved competence. You can understand, Mr. Gove, surely, why no Scottish parliamentarian with a fundamental respect for the right of the people of Scotland to choose a government of their own interests would simply sweep aside these concerns from Professor Dugan and give consent to this bill.
Which competences would the bill sweep aside?
Well, we've had many examples of policy areas where these potential divergences might be seen as politically legitimate, but the UK government deciding otherwise. I think the first policy area mentioned in the white paper was on building regulations, which have been fully devolved since the start of devolution and were separately administered even before devolution. There is no basis for saying that a divergence that would potentially create a market barrier or a trade barrier within the UK could not be justified by the Scottish Government in public policy terms. And yet there are no exemptions or derogations in terms of achieving sustainability, social justice, or other public policy objectives. Whereas in the EU, there are. Why that difference?
Well, there's nothing in the bill, as far as I can see, that undermines high-quality building standards in Scotland or anywhere else in the United Kingdom. But I also think that there's a mischaracterisation of what happens in the EU. European Union law has direct effect in the United Kingdom, as long as the United Kingdom was in the European Union and until the transition period ends. If it is the case that any part of the European Union or any individual or any government of a member state acts contrary to European Union law, then infraction proceedings begin, and it's the CJEU that decides on those. And that is why there are a variety of things that either the Scottish Government might want to do or the UK Government might want to do that we cannot do while we're in the EU. So, to take a case in point, I mentioned earlier that if we wanted to ban the sale of fur, we can do that outside the EU. We cannot do it within the EU. And as Angela Constance mentioned earlier, there is a principle, the Cassis de Dijon principle, which is at the heart of the single market, which is essentially a non-discrimination principle. So I don't understand, what the problem is in having rules governing the internal market within the United Kingdom, which are more flexible than those of the European Union. And also, I don't understand where any existing devolved competence is infringed by this legislation. We haven't seen any example of that yet, but I'm obviously alert and alive to any that might be raised.
Well, clearly we haven't seen them happen yet because the bill isn't in place yet. But even the white paper, as I've said, does mention clearly devolved competences. Under this bill, if it's passed in the current form, if the UK took a view that a regulatory divergence, an example of regulatory divergence, caused a trade barrier and had to be resolved in this imposed way, but the Scottish Government said no, it's a reasonable, legitimate trade barrier. We think it's politically acceptable. Would the Scottish Government have the power to say, no, we're going to stick with our divergent policy? Or would they be overridden?
What sort of thing were you thinking of?
Well, I've already given you an example. Do you want me to give you more examples?
Well, the example that you gave didn't apply, so I'd like an example that's relevant.
Well, if you want to understand why building regulations are included, you should perhaps ask Mr. Sharma, who refused to give evidence to this committee.
But there's no impact on the higher standards of building regulations in Scotland or anywhere else in the UK. But so let's have a real example.
if the Scottish Government or the Scottish Parliament introduced a regulation on anything, whether it's the composition of goods, whether it's the manufacture of pretty much anything in Scotland, and the UK took the view that that creates a regulatory divergence which is unacceptable, where does the power lie to judge the political acceptability of that divergence? Does it lie entirely with the UK, or would it, as in Europe, be a process of negotiation and compromise? Because the bill seems to achieve nothing by way of negotiation or compromise, nor indeed does the process of developing this bill.
Well, first of all, you're completely wrong about the European Union. If it is the case that a government passes a law that runs contrary to EU law, then that doesn't prevail. If you look at the fact-obtained judgment, for example, it's not about negotiation and compromise, it's about the direct effect of EU law. So you're wrong in that regard. On the prior question, again, I'm still looking for a hard, concrete example of a devolved competence or the exercise of a devolved competence which is infringed. Now, again, please put forward a specific proposal in the exercise of a devolved competence where this bill would, in your view, lead to the that devolved competence not being able to be exercised appropriately.
Well, I think various members already have explored specific examples, and I'm aware of time. I've given you one set of examples on building standards, which are flagged up by the UK government in the white paper, and you've simply said it's not an issue. Well, I'm not sure why it would have been raised by your own government then. Given that we're short of time, can I ask you one final question, which is you do appear to me to have the bearing of someone who is required to ask for consent, but who doesn't ultimately care whether consent is given. Are you able to reassure the committee and the Scottish Parliament that the UK will not pass this legislation in respect of devolved areas without the consent of the Scottish Parliament?
Well, not we, under the Sewell Convention, do not normally proceed with legislation if it touches on devolved competences without the consent of a devolved administration. And so far, we've managed to secure legislative consent motions for lots of bills, including, I believe, the Agriculture and the Trade Bill, and we're grateful to the Scottish Parliament and the Scottish Government for doing so. But leaving the European Union is not a normal occurrence. It is an exceptional one. I hope that we will secure a legislative consent motion, but of course, it's vitally important that we safeguard the UK internal market.
So you don't actually care about whether we consent or not?
Oh, I do. And that's why I'm appearing here. That's why we're having this conversation, because as the various bogus arguments against the bill are exploded, so I hope more and more people will realise that it is a useful, indeed helpful piece of legislation that strengthens devolution. And as such, I hope that as people have cause to reflect, support for the legislation will therefore be forthcoming from Holyrood. Nothing would give me greater pleasure.
And if it isn't, you won't legislate.
Patrick, I'll need to move on, but give others the opportunity to ask questions. George Adam, please.
Thank you, Convener, and good afternoon, Mr. Gove. Mr. Gove, you mentioned earlier on that the United Kingdom is more than its sum of its parts, and one of these parts obviously is Northern Ireland. And there's been much discussion with regards to Northern Ireland around the internal UK market and the proposals that you've currently made. With clauses 42, 43 and 45, the European Parliament has been clear that it won't ratify any EU-UK deal unless those clauses are dropped. They've gone as far as saying, the quote I've got here in front of me is, should the UK authorities breach or threaten to breach the withdrawal agreement through the United Kingdom internal market in its current form or in any other way, the European Parliament under no circumstances will ratify any agreement between the EU and the UK. Now, my question would be quite simple, quite straightforward. Are you dropping clauses 42, 43 and 45? And if you aren't, why aren't you?
No, we're not. And the reason that we're not is that we want to make sure that the UK internal market is secure in the event of a non-negotiated outcome in the conversations that we're having with our European friends and partners over the future relationship. and the specific clauses are there in order to safeguard the UK internal market. They govern or touch on a set of specific areas. One of them is export declarations from Northern Ireland into Great Britain. The Northern Ireland Protocol exists to both defend the UK internal market and to grant unfettered access to Northern Ireland goods to the rest of the UK, and also to help the UK support the EU in protecting its single market. It's a compromise in that regard. But there's no need for export declarations from Northern Ireland to Great Britain. It doesn't protect the single market, but it does bear on unfettered access. The other thing, of course, is that we want to make sure that both, when it comes to the definition of goods at risk of tariffs in the event of a non-negotiated outcome, we want to ensure that, as appropriate, that those goods which are not at risk, which are destined for Northern Ireland consumers, don't face tariffs, and we want to be able, if we can't secure agreement, to be in that position. And we also want to make sure that the state aid provisions, which apply quite properly in Northern Ireland, don't have reach back to the rest of the United Kingdom. But we hope that we will secure agreement in the negotiations with the EU on the future free trade agreement, and we also hope that if we don't, for any reason, that these issues can be resolved in the Joint Committee.
So you're on a bit of a wing and a prayer there. So for the sake of clauses 42, 43 and 45, you're quite willing to actually not drop them, not compromise. You mentioned during your answer to myself there that it was a compromise, but surely the compromise would be to work with Europe and actually find a way to get around it and drop 42, 43 and 45.
Yes.
So you do believe that would be a compromise that could be done?
We do believe that we should compromise. We do believe that the Joint Committee is there in order to find an agreement, in order to make sure that the Northern Ireland Protocol and the withdrawal agreement work in everyone's interests. But we reserve the right to protect the United Kingdom and we don't get agreement.
With the greatest respect, that's not what I asked. I asked, would you actually look at these 42, 43 and 45 and actually compromise on it itself? Because in this life, Mr. Grove, you don't always get what you want. You know,
no, but can I ask? And what we need is this legislation.
On the same point, Gove, I would just like to say that, you know, when I had a look at this, this opens up the door that there could be a potential. The Scottish Government have already said that Scottish Government ministers' responsibilities under the Ministerial Code could be breached. And I had a wee look just to see what it is. And 1.3 of the Ministerial Code says the Ministerial Code should be read against the background of overreaching duty on ministers to comply with the law, including international law and treaty obligations, and to uphold the administration of justice and to protect the integrity of public life. Now, if you take that into account, Mr. Gove, and the conversation we've had up until now, are you asking the Scottish Government to breach their own Ministerial Code?
No.
But you are, because effectively that will be the case. They'll be breaching international law.
No, I'm not asking Scottish Government ministers to do that, no.
But that George, is...
George, I think that's as far as you're going to get with that. I'm sorry.
Well, I've got a thing. Okay then, no problem.
You've got one final question.
Well, it was just one final question on the general, the whole idea of the devolved nations and all living in the United Kingdom and having respect for one another. I understand that Northern Ireland Assembly has passed a motion rejecting the internal market bill already. And is the UK government planning to ignore the voices of the devolved nations and just press ahead with legislation regardless? Because some of the evidence we've received is basically you've got the power in this scenario with the internal market bill.
No, we're working with the devolved administrations in order to make sure that we can secure not just agreement on common frameworks where work is going on, but also that the benefits of the internal market bill and the benefits of the internal market can be appreciated and shared by all.
Okay, thank you, George.